A probation violation hearing suddenly turns into a courtroom bombshell when prosecutors demand a staggering $500,000 cash bond for a mother of 6. The state claims shocking new violence happened just days earlier, and the judge is shown disturbing photos right in court. But the defense paints a completely different picture: a woman fighting addiction relapse, trying to rebuild her life, reconnect with her children, and hold down a new job. The question is, does one alleged relapse erase years of progress? And when the judge finally reveals the bond amount, even the courtroom seems stunned. Stay locked in, because this hearing escalates fast, and the emotional stakes get even higher.
Mr. Rakowski, you're requesting a bond in this matter.
We're requesting that the court do have some photographs I wish to show to the court of the alleged victim. This just happened this past weekend.
Sandra Montgomery, file number 247202FH. Ms. Montgomery appears via the Zoom application. She's currently lodged in the Huron County Jail. She's here on a request and warrant for probation violation. On behalf of Ms. Montgomery is Attorney Tammy W. Salins, who is in the courtroom, and the people are represented by Prosecuting Attorney Timothy J. Rakowski. The defendant is before the court based upon a request and warrant for probation violation dated May 11, 2026. It contains 4 counts, 2 of which are alleged technical violations, and counts 3 and 4 are alleged non-technical violations. Ms. Salins, do you wish to have the request and warrant for probation violation read into the record? Do you waive the reading?
We waive the reading, Your Honor.
All right. And you've gone over this information with your client?
I have, Your Honor.
All right. And you've advised her of her rights as well?
I have, and she did sign her advice and rights with respect to probation violation.
And that is noted. The court has received that document. As to all counts in this matter, how does your client take this?
She stands mute, Your Honor.
Not guilty plea will be entered on behalf of Ms. Montgomery, and we will schedule this for a probation violation hearing momentarily. Before we set the date, let's see. The original attorney here is Ms. Siv. We'll notify Ms. Siv. How quickly can we have a hearing, counsel?
In a week to 10 days.
Does it sound good to you?
Sure.
Okay. And are you requesting a bond?
Yeah, I'm really requesting a cash bond or a very, very high bond due to the allegation of the behavior of Ms. Montgomery of what happened to the 15 years ago.
We're asking for a $500,000 bond. I do have some photographs I wish to show to the court of the alleged victim. This just happened this past weekend. And that's why we're asking for such a high bond.
Have you provided those to the Salins?
Salin's seen them. I don't know if we've actually given her a copy of them.
Oh, just at least to let her view it, I should say. I apologize.
I did review the photo. I reviewed one photo prior to this probation violation hearing commencement.
All right. Any objections to court reviewing it for purposes of the bond?
If I may take a moment to review if there's more than one photo. I have reviewed the photos, Your Honor.
Your position on the court reviewing them?
I have no objection.
Mr. Rakowski, may approach. You can stay right there. I'll just review them very. Ms. Salins, your comment relative to bond.
This is where the defense tries to humanize Sandra Montgomery in front of the court. Notice how her attorney carefully stacks together every possible mitigating factor: 2 years sober, 6 children, daily recovery meetings, church involvement, foster care cooperation, employment, and willingness to submit to constant testing. In bond hearings, this strategy matters because the judge is weighing more than just the accusation. They're evaluating risk, accountability, and stability. But here's the difficult part: prosecutors are simultaneously presenting alleged new violent conduct backed by photographs the judge personally reviewed. That creates a massive credibility battle inside the courtroom. One side says this is a struggling mother trying to recover. The other side says she's a serious danger who just escalated into new criminal behavior. What do you think the judge focuses on more in moments like this, rehabilitation or public safety?
My client would like the court to know that she has abstained from alcohol for approximately 2 years. This is the first time that she has relapsed. She has indicated to me that she has 6 children, 5 of them are in foster care. She is working closely with the foster care worker.
You sure about that? You sure about that?
For regarding visitation and treatment. She has agreed, they had a TDM meeting this week, and she has agreed to recovery meetings every day. She would also like to go back to Chance to Change so that she can test either randomly, but she's also willing to test daily. She just started a job at Taco Bell, Your Honor, and she has been there approximately 2 weeks. She has worked from 30 to 40 hours a week. She is asking the court to set bond in the amount of $5,000, 10%. Her children are her life. She is absolutely committed to working with the Department of Health and Human Services regarding visitation and treatment and complying with any services that they are requesting. She also advised me that she belongs to the Lighthouse Assembly of God in Harbor Beach, where she attends there, and so she would ask the court to set bond the amount of $5,000, 10%.
Very well, thank you. The court's had the opportunity to hear the respective argument of counsel, hear the recommendations for the probation department. Court's also had the opportunity to review the photos of an alleged incident, which, are there charges brought, Mr. Rutkowski, in that matter?
There will be, Your Honor. I'm looking for a warrant request. Once I get that, we will act upon it.
All right. And is this an alleged domestic relationship? Or at least?
No, not that I'm aware of this one.
Okay. All right.
Would the court like me to remind you of what had happened earlier this year or no?
I recall that.
And there it is, the moment that completely changes the tone of the hearing. A $500,000 cash surety bond is an extremely serious condition, especially in a probation violation case. Judges usually reserve bond amounts this high for situations where they believe there's a major public safety concern, a risk of reoffending, or danger tied to the alleged conduct. What's also important here is the added restrictions, GPS monitoring, alcohol tracking, pre-trial supervision, and a strict no-contact order. That tells you the court is trying to create maximum control over the defendant if release ever becomes possible. You can actually hear the surprise in the courtroom immediately afterward when clarification about the bond amount is requested. This wasn't just a warning from the judge, this was the court sending a very strong message about how seriously it views the allegations.
Okay, I do recall that. Based upon all of that, it's going to be the position of the court relative to bond in this matter. Bond is going to be set at $500,000 cash surety. Conditions of bond include conditions A through E, GPS tracker, alcohol sensing tracking device, and must be pretrial services beforehand. Also, no contact provision regarding Christina Bresky, Christina Bresky, either directly or indirectly. And that will be the bond. That'll be all in that. Off the record.
Sorry, what was the one?
$500,000 cash surety.
You tested negative today, is that correct?
Yes, Your Honor.
All right. So one of the things that we talked about last time you were here was that you be compliant with all of the orders of this court.
Yes, sir.
I understand you have not been calling the CIP line every day?
I text it every day, so I can show you proof of my phone.
There has been 7 days that he's missed, Your Honor, and then on April 30th, he texted it, told him he had to test, and he did miss. He's stating he did try to call me, but I have no verification, and he did not try to call the front desk or his GPS officer either.
I did do that, sir, and my phone was off for 7 days, then I paid my phone bill, and then I started texting the testing line again every day.
But you just told me that you'd done it every day, and then I find out there were 7 days in a row you missed.
My phone was off, sir.
Do you live by yourself?
Huh? No, my mom.
Does your mom have a phone?
Yes, sir.
If
I
you-
didn't know I could text the testing line off of another number.
He was made aware, Your Honor, that I could switch the phone number, but he also has missed multiple office visits or would show up hours late, so I was unable to always verify
I
that
missed
information.
one office visit, sir. That was the 30th.
Look, I'm not gonna get into an argument with you about this. You know, I'm gonna release you today, but I'm gonna set this for another review in 30 days, and you're gonna come back, and you're gonna understand that when I tell you to do something, you're gonna do it as I say. Do you understand me?
Yes, sir.
Listen, this is not complicated. This isn't rocket science. The things that I have in place for you are designed to hold you accountable for my orders and to be a better citizen. That's what we're trying to do here.
Yes, sir.
Okay? I'm really not trying to punish you, but I am being very stern with you because I want you to be a successful person. Not just get through probation. I want you to be successful after this.
Yes, sir.
So follow the rules to the letter. Come back in 30 days. I expect negative on the THC. I expect you to be 100% compliant with calling the line every day. If there's a problem, your phone gets shut off. Borrow your mom's phone. Call your probation officer, explain the situation. She can, again, we can work with those things, but if you don't communicate, if you don't show up, we just have to assume the worst. Do you understand what I'm saying?
Yes.
So that's what happens is I start assuming, oh, he's using, right? He's not calling, so that for that 7 days, you're doing something that you shouldn't be doing. That's what these things are designed to do, is to hold you accountable. Do you understand me?
Yes, sir.
I know I'm being harsh on you, but I'm trying to get your attention here so that when you get done with probation, you can lead a successful, law-abiding life. That's the goal here.
Yes, sir.
Right? Reducing recidivism.
This courtroom sequence really highlights two completely different sides of the justice system. In Sandra Montgomery's case, the court focused heavily on alleged new violent conduct and imposed an enormous $500,000 bond despite arguments about recovery, employment, and family responsibilities. Then, in the Matthews review hearing, we saw the judge take a much more corrective and rehabilitative approach, emphasizing accountability, communication, and long-term success instead of immediate punishment. It's a reminder that probation hearings are often less about the original offense and more about whether the court believes someone is truly following the rules and making progress. One missed step, one relapse, or one new allegation can dramatically shift how a judge responds. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.